So good afternoon, everyone, and welcome back to our weekly webinar series on IBC. We had started the topic on verification of claims under IBC last weekend, and today we are continuing the same. We had talked about the various litigations and the various judgments and the provisions in brief with respect to claims in IBC process, the delays and the effect of delays in filing, etc., etc. Today we will continue that, and we are both in Bhopal, and we're taking today's session from here. So over to Anil sir.
Thank you very much, Ankit. In case we give a little recap, so first we discussed about the definition of claims, and one thing which is very important for everyone to understand again, that this judgment, as far as these claims are concerned, just to give a recap, the claim is not regarding whether it is reduced to judgment, whether it is disputed, undisputed, whether it is matured, whether it is liquid, legal, equitable. It is not anything about all this. It is about right to payment. Right to payment is something which is very, very important. And also, in case you see this second clause, it is right to remedy for breach of a contract where it gives a rise to payment. Again, right to payment is something which is very important, because in today's various jurisprudence, we will also discuss whether the maturity of claim, whether all this is relevant or not. And then we discussed about various forms, various discussions, and the distribution of assets under Section 53, because the claim depends, the verification of claim depends under what clause of Section 53 that claim will fall. So whenever we do verification, it is very, very important that we should also inform the claimant that your claim has been admitted in this clause of Section 53 1A or 1B or 1C. This is something which is very important for all claim verifications. So we actually had seen the claim, in fact, we discussed belated claims during CIRP, and there were two parts of it. One was before approval of the resolution plan, and we have said that it is different. We have seen various jurisprudence which are different for where the resolution plan is not yet approved by the adjudicating authority. However, where the resolution plan is approved by the adjudicating authority, it is different. We also have seen that it is different in the case of home buyers, and because the courts are taking different opinion in the case of home buyers, and also in the case of workmen and employees, there is a different. So all this we have discussed in the part 1 of our webinar, titled as Claim Verification and Jurisprudence thereunder. So after the approval of resolution plan, it has also been, it was also discussed that after the approval of resolution plans, like there is all likelihood that your claim would be considered as extinguished, and you will suffer because of the belated filing of the claim. So after the approval of the resolution plan, there are various cases where the claim definitely can actually get extinguished. Your entitlement will be finished. So all this is very important for understanding. So today we would actually start from maturity of claims. So maturity of claims, and we start with this first judgment of NCLAT. And this first judgment of NCLAT talks about this is again like March 22 judgment. In this particular case, it's a very small issue. The IRP, who was in fact replaced with another IRP, he claimed for some legal expenses, and then the order was passed by NCLT rejecting the claim of the appellant. So the IRP went to NCLAT, and NCLAT also said that if the COC has not approved some expenditure, it is not something which is a material irregularity or patent illegality in the eyes of law. COC can consider or can disapprove the expenditure. Then we have again latest judgment in February 22, Axis Bank versus Samruddhi Realty Limited. And in this case, it is a case of home buyers, and the home buyers in fact approached the Axis Bank in this case for financial assistance. So the Axis Bank gave assistance to home buyers, and that disbursement to home buyers, this was again, it was given to the corporate debtor. It was given to the corporate debtor, and the corporate debtor went for CIRP. Now the Axis Bank in fact filed its claim to the corporate debtor, whereas the loan was given to the allottees. So in this case, the MCLAT said that the Axis Bank has got no right to file claim before the corporate debtor because this money was not disbursed to corporate debtor. And as Section 5, subsection 8 says that the time value of money as per Section 5(8) was not there. So it was rightly rejected by the liquidator. So, Ankit, there is another judgment which is in May 2022, again a very latest judgment, and this is from Supreme Court of India, PTC India Financial Services Limited versus Venkateshwaralu Curry. So, in this case, it was a case of the pledge of shares, and the pledge of shares was done after the pledging, even the dematerialization right and the pledgee in fact became the beneficial owner. Pledgee also registered itself as the owner, and the signatures also were replaced. And however, the shares were not sold. And this claim was filed. So then the Supreme Court held in this case, the beneficial owner is changed. However, the shares were still in the name of the corporate debtor, and therefore the claim can still be filed because the asset is in the name of the company. Asset is still in the name of the company, although the beneficial owner has been changed. So that doesn't matter. But therefore, the Supreme Court said that the replacing the name of signatory, that doesn't mean that he has no right to file claim. So he will have the right to file claim even if he has changed the name, he has changed the signature, beneficial owner, he has been registered. Then we also have another judgment from Supreme Court of India, and that's Kotak Mahindra Bank versus A. Balakrishnan, and again, like May 22 judgment. This is a very popular judgment, and this is where the Supreme Court has held that the recovery certificate issued by Debt Recovery Tribunal, that will be considered as a financial debt within the meaning of Section 5, subsection 8 of, and consequently, the holder of a recovery certificate would be entitled to initiate CIRP, and that also means that he will also be entitled to file claim. However, the limitation period would be applicable, and that would start from the issuance of recovery certificate. So, a very important part in this judgment, I read this judgment in detail. It was also kind of observed that in case the original debt was an operational debt, and the recovery certificate was given to an operational debt, then the nature of the claim would not change by just getting a recovery certificate. Recovery certificate is a kind of further added evidence that there is a debt. However, recovery certificate would not change the status of the or the nature of the claim. In case the underlying transaction was for operational creditor, it will continue to be an operational creditor even after getting the recovery certificate. If the underlying transaction was a financial debt, it will continue to be a financial debt even after getting the recovery certificate. Then, of course, this the April 22 judgment, Sunil Kumar Jain versus Sandesh Bhatt, this was on workman's claim, and this was also on a kind of very short, very brief judgment on provident fund, pension fund, and gratuity fund. And this we are referring again wherever the workman claim is under dispute regarding provident fund, pension fund, and gratuity fund. Along with this, we are also referring to the judgment of Savan Godiwala, the liquidator of Lanco Infratech, that was given by Justice VP Singh in NCLAT. So these two judgments are presently we are using for saying that if there is no fund maintained by the company, then the pension fund, provident fund, and gratuity fund would be considered as workman dues and would be dealt with under Section 53. In case the funds are maintained by the corporate debtor and there is money in these funds, that money would be kept outside the resolution or liquidation process, and that money can only be used for payment of workmen or employees with regard to provident fund, pension fund, and gratuity fund. So these are two clarities that we have got so far. However, this Moser Bear and this Savan Godiwala both are separately pending before Honorable Supreme Court for a final decision on this issue, whether the Provident Fund, Pension Fund, and Gratuity Fund has got a super priority or not. But this judgment is briefly attending to this issue. Sunil Kumar Jain versus Sandesh Bhatt is briefly attending to this issue. And very important part of this judgment, and which is the most spoken part, is the how to handle the workmen and salaries during CIRP. So it is very clear in this judgment that the workmen and employees, they can only claim salaries during CIRP in case they actually provide service to RP, or in case they actually provide service to RP. Now, anyone who is not providing service to RP, simply they're being on the attendance register, or they're being on the panel of the, they see if they are on the recruitment of the company, that will not entitle them to salaries and wages. This particular subject was first taken up in Jet Airways insolvency process. In the Jet Airways insolvency process, the claim from workman and employee was more than 700 crores during CIRP, and the resolution plan said that the salary will be paid only to those employees who actually worked with the RP for the process or for the operation. So it is also said in this judgment, Sunil Kumar Jain, that in case there are workmen and employee on the roll of the company, then it is the duty of the RP to assess the profile of the workmen, their contribution to the operations or to the process, and present this analysis before the first committee of creditors meeting, and should get an approval from the committee of creditors meeting that these are the people they are required for the company to function, or they are required for the process of resolution of insolvency. So the major part of this judgment, Sunil Kumar Jain, is on this. So therefore, it is the obligation of all the insolvency professionals that in the very first meeting, they should bring details of each and every workman and employee along with their decision, whether it should be retained or it should not be retained, and accordingly should get approved from the committee of creditors. So this is a very, very important judgment, Ankit. And another order from Supreme Court of India in February 2022, that is Consolidated Construction Corporation Limited versus Hitro Energy Solution. In this particular judgment, you would again we would say that this it's a very latest judgment. Advance given to corporate debtor for supply of goods or for services would be considered as operational creditor. This was held in this case. We have been talking about section 5, subsection 8 and clause F. In this clause, it is written that any payment made for any future purchase or sale would be considered as financial debt. And under this section only, the Supreme Court has held that the advance paid by the home buyers who are allottees of a project would be considered as a financial debt, unsecured financial debt, and that's what is presently valid. However, with this judgment, and that too from Supreme Court, it is now, we would say that for the time being, it is final that any advance paid for supply of goods or services would be considered as operational debt unless it is a case of allottee. So this clarity has come from Supreme Court in the case of Consolidated Construction Consortium Limited, and this again in February 22. So Ankit, what has happened is that so far we actually have been reading that section, which is probably, I understand that the check is given by a person. Suppose he's trying to get a power plant made, so he may give crores of rupees for as advance money. But in case the power plant is not disbursed, we've been thinking as per section 5(8) clause F, it would be considered as financial debt. However, with this judgment of Supreme Court, for the time being, the law has been made that it is not. So this probably this is the so this is something that we have to accept now, unless it is changed in future. So in case you can take up a couple of judgments, Sanket.
Sure. So this one, next one that we have on our list is Exim Bank versus Resolution Professional of JEKPL Private Limited, NCLAT. And this one is 2018 judgment. Here, the judgment talks about it was held that maturity of claim or default of claim or invocation of guarantee for claiming the amount has no nexus with filing a claim pursuant to public announcement made under Section 13(1)(b). And read with this section for collating the claim under Section 18(1)(b) or for updating the claim under Section 25(2)(e). So that way, this one de-attaches the idea that the guarantee should be invoked or there should be a default for the guarantor to, for the creditor who has a guarantee from the corporate debtor to file a claim before the RP or the IRP. So next one is next one is Edelweiss Asset Reconstruction Company versus V. Mahesh IRP in the case of Vasan Healthcare Private Limited. In this case, the maturity of a claim or default of debt are not the guiding factors to be noticed for collating or updating the claims. Therefore, there will be acceptance of claim against corporate guarantee without invoking it. So these two issues, two judgments in a way, talk about how corporate guarantee related claims have to be admitted and there shouldn't be any invocation for the claims to be taken care of.
Ankit, I would like to add in this case, I would say that this is a concept that we need to explain. Now, the concept is that default is not required for claiming any money. Whether the payment is due, that also is not required for claiming any money. Whether this claim is matured, that also is not required for claiming any money under IBC. Whether there is a arbitration pending or court case pending and the claim is not matured, it is still disputed, nothing is required for filing a claim. And this is also extended to a corporate guarantee. In case a company has given a guarantee to corporate debtor and the corporate debtor has gone for insolvency, so the company, the guarantor company, will file its claim irrespective of the fact whether that has been invoked or not. However, in practice, in case the guarantees are not invoked and we get a claim filed, normally we consider it as contingent claim. But even if we consider them as a contingent claim, we give them voting power. Because as far as the disbursement is concerned, in case of resolution plan or in the case of resolution finally, that will depend upon whether finally the invocation has been done or not. And in case of voting, In case of decisions by the committee of creditors, they are definitely their claimant, because it is very easy to get non-fund based facilities to get converted into fund-based facilities. So therefore, their right to vote is there. Their claim is considered as contingent claim, and the disbursement will depend upon whether the claim has been invoked or not. In case the claim has not been invoked and the resolution applicant takes the responsibility of that particular guarantee. So these are different issues. So I'm presently staying on the maturity of the claim, but this is a very important subject. So Ankit, you can go ahead now.
So these are judicial pronouncements now on collation and verification of claims under CIRP. So this one is again a recent judgment, Mascot Petrochem Private Limited versus Midas Construction Company Limited. It was held in this case that where operational creditor had not been able to show convincingly that it had actually supplied materials as claimed to corporate debtor, and corporate debtor came to know about said claim after it received the demand notice. Dispute raised by corporate debtor as regards said claim was legitimate, and therefore application filed under section 9 by operational creditor lacked merit and was correctly dismissed by NCLT. Why are we looking at this judgment from the claims angle? I believe it is important for us to understand that what would happen for this person's claim had the claim come during the after the CRP had initiated. Um, Similarly, we have Rabinathan versus Pravincharan Dwari. Here again, it was said that since all claims are to be filed in IBC, even if right to payment is reduced to judgment of a civil court, same is also a claim at par with other claimants as referred to in section 3.6. So in the first judgment, we can go ahead and say that uh, Mascot Petrochem, what would happen? The discussion point is what would happen if the OC, the same OC, would have filed a claim before the IRP or the RP after initiation of insolvency. What would be our role as an RP? So maybe our role in an RP would not be to adjudicate it, but if there is a disputed claim for which certain documents are not available with the claimant, then we will have to ask for those documents. In this case, there was lack of those documents. Champa Impex Private Limited versus PM Cold Storage Private Limited, NCLT Kolkata bench judgment dated March 2022. Here the facts were that the applicant sent email attaching the claim form, ledger, bank statements, PAN, Form 3, etc. And it was specifically mentioned that the amount advanced as loan to the corporate debtor was given on various dates highlighted in the bank account statement in Form C. The RP has not disputed the advancing of loan by applicant to the corporate debtor. All these entries are reflecting in the books of accounts, and the amount has been transferred through banking channel. The existing of these entries cannot be denied by RP. The only thing disputed by RP is that there is no loan agreement relating to the said loan. The applicant has sent along with the claim all material documents like ledger, bank statement, etc., which has probably not satisfied the RP. So it was held in this case that the claim of the applicant should have been considered and accepted on merit, because as per the latest judgment of Honorable Supreme Court of India, the balance sheet of the corporate debtor reflecting the loan of the applicant should have been sufficient ground for acceptance of claim submitted by the applicant. There is no necessity for the applicant to file any loan agreement in its support, particularly when the parties were related to each other and had common directorship in the two companies, and therefore did not think it necessary to execute such a loan agreement. So it happens quite a few times that you have certain amounts coming in, or rather going out, and maybe a debt is created in that manner. Maybe that money coming in or money going out is something that you see historically in the bank statement of the company. Now, how do you assume that it is a loan? So, what this judgment relied on in Kolkata NCLT was that in case the bank statement says that this amount was indeed taken, then it was taken. It was a loan, then it was a loan. Himalayan Crest Power Private Limited versus Pankaj Khitan RP of Sasi Power Limited. This is a February 22 judgment. And in this case, it was held that where there was inordinate delay of 9 years by appellant financial creditor in recognizing interest income in its balance sheet on loan given to corporate debtor, and also there was no corresponding booking of interest in its accounts by corporate debtor, appellant's application for its claim of interest component on loan advanced by corporate debtor was rightly rejected by AA. So in this case, I would say that many companies would not recognize the interest income in their balance sheet, and this judgment can be a reason for that interest not being permitted as a claim. So whether you're in case you say have some money due from somebody, even if you are if you don't book the interest in that account, this might become a problem. So it is always perhaps a better idea to book the interest and then reverse it. Many banks also don't book any interest in their balance sheet in case the account is NPA. That, however, is a statutory requirement that they should not admit any income from the said account where the account is where the account is an NPA. Drive India Enterprise Solutions Limited versus Valley Group 2022, again a January 22 judgment, recent one. It was held that where appellant filed an claim as an operation creditor before the RP, but resolution professional did not inform RP or NCLT about appellant's claim as he wanted liquidation order to be passed against the corporate debtor. Impugned order against passed by NCLT ordering liquidation of corporate debtor was to be set aside and matter was remanded back to NCLT.
And in this kind of scenario, you see, we can see that the RP, in fact, did not inform the committee of creditors or NCLT about that claim, and that claim was not even accepted, not even. So this is something which is a non-compliance. So in fact, I would say that the RP or IRP is duty bound to deal with each claim he has received, and in case of any confusion, he should also take suggestions from committee of creditors, or he should reject or accept with proper reasoning, then giving a right to the other person to file an appeal in case the other person is aggrieved. So very correct. So I'll just go to this judgment again from NCLAT in May 2022, Employees Provident Fund Organization versus Subodh Kumar Agarwal as RP of Ambient Computronics Private Limited. Again, a judgment on the EPFO. It is held in this case that the provisions of the code and regulation do not contemplate any cognizance of any ongoing proceedings under which corporate debtor may be saddled with any liability, financial or otherwise. The present case is a case of that nature where, in spite of director of corporate debtor and resolution professional being aware of the inquiry under 7A, did not take steps to inform the department concerned to file its claim in CIRP, and both resolution professional and resolution applicant now contend that no claim has been filed by the appellant. So there is no error in the resolution plan not noticing and reflecting their claim, although section 18 of the code uses the expression collate all the claims, but the said expression being followed by the words submitted by the creditors. The resolution professional is entitled to contend that unless a claim is received by him, he has no obligation to include it in the list of claims or even the information memorandum. So the EPFO, the Employees Provident Fund Organization, in fact, argued that the inquiry under section 7 capital A was pending. So the information before the RP and the corporate debtor was available that there are dues. This information was not provided in the information memorandum. This information was not even provided in the, they didn't ask for the claims. But however, finally, NCLAT said The resolution plan has been approved. There is no error by the resolution applicant about not including this claim in the list of creditors, because it is very clear that it has to be submitted by the creditors. The claim was not submitted by the creditors. Therefore, the RP was absolved from his responsibility to take and admit all the liabilities of the company, because it is followed by a word kind of submitted by the creditors. Going forward, we have this case of Sri Krishna Constructions versus Vasu Devan. He is the RP of Tiffins, Barrett's, Asbestos and Paints Limited, unclear judgment. And it is held in this case that while examining, the IRP did not find any appropriate document to support the claim. As such, the IRP may not be held, may not have considered the claim, and the adjudicating authority have looked into it and did not find anything wrong with the act of collating done by the RP. CIRP process cannot be converted into adjudication forum to settle claims already in disputes in court. So this is again a concept that we need to discuss, that it is not the duty of the IRP or the RP to adjudicate the claim. It is not an adjudication forum. In case the documents are complete, he would admit, maybe even disputed. In case the documents are not complete, the IRP will not admit the claim. So whenever the claims that you have to accept the claim, it has to be complete with the documents. So in case the documents are not complete, a deficiency letter should be issued, and then only the claim can be admitted. Going forward, the DIPCO Private Limited versus Jayesh Sangrajka, and again unclear judgment in January 2020. It is held in this case that the decision for collating the claim, if any, taken by the RP, the same being judicial or quasi-judicial, NCLT cannot sit in appeal. In the present case, though the adjudicating authority has no jurisdiction, but for the purpose of transparency, considered the documents relied upon the respondent in support of their claim, and observed that the basic principle is that the documents speak for themselves. A simple verification of the above documents, in fact, are sufficient enough to conclude that corporate debtor has a liability to pay the amount as claimed in the documents. So, in case the documents are speaking for a claim, then the RP should admit it. And in the above judgment of Shri Krishna Construction, we've seen the documents were not available, so it was rightly rejected. In the judgment of DIPCO, it is seen that the documents were speaking for a claim, so the rejection was not okay. So the basic collation and verification of the claim duty is depending upon the documents which are attached and not on the adjudication. And also kind of something which is the RP is not disclosing with the committee of creditors, and also taking some kind of decisions which are not transparent. That is a concern. Otherwise, the RP has its duties. Now, this Supreme Court judgment is a very old judgment. I think it is the prime judgment of Insolvency and Bankruptcy Court, which is the Committee of Creditors of Essar Steel India Limited versus Satish Kumar Gupta in November 19. And this was in the case of Essar Steel, I believe. It was held in this case that the role of the resolution professional is not adjudicatory, but administrative. Further, with respect to the claim, it has been stated that the CIRP, all claims must be submitted to and decided by the RP, so that a prospective resolution applicant knows exactly what has to be paid in order that it may then take over and run the business of the corporate debtor. So because of this judgment, because of the various wordings used, now in most of the judgments are coming that the RP is having the responsibility of bringing out all the liabilities in front of RA. Even if some claims are not filed, it actually is becoming his duty. Even these proposed regulations, which we have seen as discussion paper, it also proposes that based on the books of accounts, the RP is required to communicate with all the creditors as per the balance sheet and the books of account, for that they should file their claim. So it is also in this case said that it is required. So Ankit, I think you can now take up some part of this IBBI discussion papers from here onwards?
So, IBA came out with a discussion paper on the changes in the CIRP process dated 27th June 2022. We have already discussed this, but we are discussing those paras which are part of this discussion paper which relate to verification of claims. So, one, there is an introduction of Regulation 40A in CIRP regulations, which talks about change in timelines for activities under CIRP. So in case you see the existing client timelines versus the proposed timelines, now the idea is to uh, prepare the IM and do the claim verification process in a way a parallel system. So in case you look at the existing timeline, it talks about how the submission of IM to COC was earlier planned at a time which is within 2 weeks from the appointment of RP, but not later than 54th day. Now it is within 95 days of the commencement. Similarly, publishing the Form G is now earlier. So let's, I think, move on to the next list. So the existing framework, it says that in public announcement for receiving claims, the IRP provides an email address that he operates or uses. So the issue is that frequently the IRP may be remitted from office or some other RP takes over. So in that process, the email address and all the communication that the IRP has received on the email address, or he might receive on that email address in future, does not get passed on to the RP. So now it is proposed to be a requirement that the IRP shall be required to open an email account for conduct of CIRP and hand over credentials of the same to the RP while he demits office. The RP should also hand over the credentials to the other RP in the event of replacement or liquidator. So whenever you are so the first 2 days, 3 days when you're making a public announcement, when you get a case as an IRP, you're supposed to put an email address to it. So after the change in regulations, the email address should be such that it is transferable to the new person. Need for IRP, RP to communicate to call creditors to submit claims. So the issue is that the claimant creditors are unable to file claims due to reasons like lack of information about the CIRP. So common occurrence in real estate cases where lottees are not in touch with the CD. So the proposal is that the IRP shall communicate the initiation of CIRP and the details of public announcement, including the last date of submission of claims to all creditors of the CD. So now the IRP has to send specific communication. He can't say, I got a newspaper advertisement published, I don't want to do anything else. The need for IRP RP to communicate to call creditors. So that is again, this is the proposed amendment there, that notice to known creditors. So it says that the interim resolution professional shall send notice to all the known creditors of the corporate debtor, which shall contain a copy of the public announcement made under Regulation 6. The notice may be sent through post or through electronic means to such creditors. And of course, there's an explanation which says that known creditors of the CD shall mean the creditors reflected in the books of accounts of the corporate debtor available with the IRP or information received from any other source as the case may be. So what can be this source? One, you can have MCA based data where you have all the list of or details of charges which are registered against the company. So then you can try and approach the people who have a charge registered against the company and ask them to file their claims. Secondly, you can look into the books of accounts of the company and see where all there might be a contractual liability or somebody might be reflecting in the balance sheet as a creditor, which you then reach out to. I believe this is not really claim related. Let's proceed. Yeah.
Yeah, this part is important, Ankit, because see, the contents of information memorandum that has actually been enlarged a lot. I think this you should take up.
So when it comes to contents of IM, now we had shared earlier that there's so many judgments that had come out that in the IM, the RP was supposed to make disclosure of claims that were received, which were not accepted, claims which were received in a delayed manner, and so on. But what are we looking at now? So the existing law says that Section 29(2) of the code provides for preparation of IM by RP, which shall include financial position of the corporate debtor or information relating to disputes by or against the CD and any other matter. And Regulation 36 provides the mandatory contents of the IM. So the IPs and the issues are the IPs and COCs do not pay enough and close attention to the preparation or approval of the IM. This restricts the information available to the resolution applicants. Then it says the IM does not reflect the unique selling proposition of the CD and does not provide a clear picture of CD's strengths and prospects. So let's see what are the other issues or changes that they're proposing in the IM. So what is the proposal? The proposal is that the RP shall include, as part of the IM, a clear picture of the CD's business performance, business evolution details, key contracts, industry overview, including sector fundamentals, key growth drivers, projected business plan, key investment highlights, etc. And it should reflect certain details that would attract, incentivize the prospective resolution applicants, such as brought forward losses in the income tax returns, income credit of GST, key employees, key customers, supply chain linkages, utility connections, and other infrastructure facilities that will take a lot of time to be set up. So why are we talking about in the claim verification process? So there will be certain information that will come through the claim verification process. So we keep saying that, say there is a case where the books of accounts are not available to a CD, which is maybe a real estate company. In that case, the details with respect to what was the total amount that was fixed for sale of the assets, what is the amount that is received, what is the amount that is balanced, what is the kind of consideration that was being taken from the people who had purchased the house, purchased the properties. So all these information comes from the claim verification process, which can also help filling up the IM. Another thing is in the IM, in case we look at books of accounts of the CD, in case they're available, and see that there are certain liabilities which are not where the claims have not been received, mentioning those liabilities or those credit balances in the IM are very, very important now. So therefore, there has to be an exercise to reconcile the books of accounts with the claims, but not with the objective of verification of claims. Verification of claims can also have an impact in case the said claim is part of your books of accounts, but more to do with filling up pendency in the IM wherever the loans are pending, but nobody's claiming them.
Now, Ankit, we should also move on to the claim filing and verification in liquidation process.
And we can take some questions. We can take some questions.
Can take some questions. Yeah, I think this liquidation also will take some time, but then we can take some questions. Yes.
So Mr. Virappandian is asking that in the event of absence of contact information about the known creditors, how the RP, IRP can communicate to creditors, assuming that the CD is also not maintaining such information updated. Many information can come from say you come to know that this XYZ Private Limited is a creditor. In that case, these days, asking any person to look for the contact number of that person online is a fairly easy job. Many people have their information there. The other sources can be in case contact information is a problem and the name is available, then I would say public information would only come to your rescue.
No, I think Ankit, you are right, but then I'm only trying to say that about this question, the most important is the efforts made by the insolvency professional. He may be IRP or RP. If he has made the efforts to find out the contracts, I think that releases him from his responsibility. But in case he has not made his efforts, then it will be difficult, and then the courts will say that it was your duty to communicate. I mean, of course, when this regulations also would be notified, then it will be said. But presently, this is a duty based on the judicial pronouncements. Yes, I think we can take next question.
So he has a further question, Mr. Virandapian, that can such communication be completed within 7 days? So my thought process is that wherever this information is available in the first few days of the CRP, of course, that is where this effort will go in, where you don't have details coming in from the previous management with respect to who are the creditors as per the books of accounts. There, maybe nobody can expect this from you, that you will also contact the creditors within the first 7 days. Mr. Vaidyanathan is asking that projected plan which already erstwhile board prepared, RP has to prepare the future scenario of the company. May please clarify. So our opinion is that maybe the previous scenario prepared by the company might be a very different one, may not be in line with the expected outcome of the CRP or the or the outcome for the prospective RA based on the changes in the conditions. So preparing a fresh plan would perhaps be a better idea. That plan might borrow a lot from the previous plan available in case the circumstances have not changed.
But Ankit, when we prepare the projections in information memorandum, the only clarity that we need, whether the prospective haircuts that we would be in this particular case based on the liquidation value, whether that has to be accounted for in the projections or not. So there can be two kinds of projections. One projection in case of a zero haircut, then what kind of projections would be there? And the second would be in case of haircuts equivalent to the liquidation value, which again is a concern whether the liquidation value can be disclosed or not. But approximately, considering that the resolution plan will fetch something which is close to liquidation value, and there can be two kind of projections that can be made. So it is not possible for the RP to prepare an information memorandum with the projections where the entire haircut is also accounted for, or no haircut is accounted for. So I think there needs to be two projections assuming some kind of facts.
Right. So another question is, IRP admitted the claim of a bank on the basis of documents provided by the bank. Now can IRP revise the admitted claim of the bank when the suspended director challenged the claim of bank after admission of claim of the bank? Now IA is subjudice. So this is from an anonymous attendee. Here I would say that maybe if the documents that have been provided by the promoter or suspended director reveal something that changes the RP's opinion about the bank's claim, then he can revise the claim. But in case that is not the case, then the claim will remain as it is. What is your opinion?
And I think he will wait for the adjudication. No? See, what is the question? The question is the matter is already under.
So now that the matter is subjudiced, that's of course something that he will wait for the decision of the court. But wherever the matter may not be subjudiced and a claim has been accepted based on documents provided by a claimant, and subsequently based on some other documents you realize that no, the claim amount or the claim admitted should be different. So you can change it based on fresh information coming to you.
No, I just want to add that even if the matter is sub judice, if the RP has got information subsequent to his decision, and that information is sufficient for admitting a claim, then RP can still admit a claim even if the matter is sub judice. This is what I want to add.
I think the issue is that he's admitted the claim, but then the claim is supposed to be revised downward because of some change in perspective or change in documents available, where the allegation is that the bank's claim is excess and has been accepted by the RP above the exact amount.
You take another question. I'll just.
Yeah. So Mr. Rajkumar Mahato is asking, what is the correct stand in including claimant in creditors list pending receipt of some documents desired by IRP RP liquidator? I believe in case there are the documents which are pending are crucial to establish the claim, then it can be kept pending because it is a duty of the IRP, RP, or the liquidator to ask for those documents and complete those documents. And where the creditor has stated that the documents are not available or will be available only after some time, then the RP can choose to provisionally accept the claim depending on the acceptability of the claim without those additional documents. It will happen or will vary from case to case. Vinay Kumar is asking, the RPs take a long time to acknowledge claims submitted by individuals and communicate the same on the plea that there are many claims and that will take time. If there are, if is there any time limit set as per rules for RP to communicate claims of COC as individual member? Uh, uh, I think it might be an exception that the RPs are not able to process the claims in time. Normally RPs are able to accept, and they, if the case is larger, they would then deploy the resources so that adequate resources so that the claims can be processed in time. There wouldn't be too much delay there in normal circumstances because the rules are very clear that before you want to set up your first COC, you would normally want to have all the members of the COC completed, completely compiled. Then we have a question that if there is a deficit in PF trust, where the deficit is to be met by RP, if yes, whether along with secured debts or as operational debt. So yeah, you are saying that there's a PF trust, there is a deficit in the PF trust to pay the PF which is due on a particular date to the employees, because maybe the company has not been able to contribute towards the deficit for the past few years.
I think a deficit in PF trust is almost akin to which is the payment due to EPFO. So there is no difference between a PF trust maintained by the company or the amount which is due to EPFO. So both will have the same treatment, amount due to EPFO or amount due to the trust maintained by the company. Both will have the same treatment. The treatment would be different only in case there is a provident fund and there are money in that provident fund which is in the control of the corporate debtor, and that money cannot be touched by the RP. That has to be paid to the workman. That's what is the difference.
So I believe we can move forward now.
Okay, so I think let's spend some time on this claim filing and verification in liquidation process, and let us see the couple of sections that we have. And the section says that the sections are saying that the filing of the claims as per regulation 12 of the liquidation process, liquidator is responsible for verification of claims in liquidation process. Now, in the case of CIRP, it is the collation of the claim, and in the case of liquidation, it is the verification of claim in the liquidation process. And again, as per regulation 31, the liquidation process regulations, the liquidator shall prepare a list of stakeholders category wise on the basis of proof of claims submitted and accepted under these regulations, with the amount admitted, extent to which the debt or dues are secured or unsecured if applicable, the details of the stakeholders, and the proof admitted or rejected in part. That's what is the regulation says. Consolidation of claim is dealt with by section 38. Liquidator shall receive or collect the claims of creditor within a period of 30 days from the date of commencement of the liquidation process. A financial creditor may submit a claim to the liquidator by providing a record of such claim with an information utility, provided that where the information relating to the claim is not recorded in the information utility, the financial creditor may submit the claims in the same manner as provided for the submission of claims for the operational creditors under section 3. The operational creditor may submit a claim to the liquidator in such form and in such manner and along with such supporting documents required to prove the claim as may be specified by the board. A creditor who is partially a financial creditor and partially operational creditor shall submit claims to the liquidator to the extent of his financial debt in the manner as provided in subsection 2 and to the extent of his operational debt under subsection 3. A creditor may withdraw or vary his claim under the subsection within 14 days of submission. The regulation, the section 39 says verification of claims, which says the liquidator shall verify the claims within such time as specified by the board. The liquidator may require any creditor or the corporate debtor or any other person to produce any other document or evidence which he thinks necessary for the purpose of verification of claim. Again, section 40 says the admission or rejection of the claims, the liquidator may, after verification of claims under section 39, either admit or reject the claim in whole or in part as the case may be, provided that where the liquidator rejects the claim, he shall record in writing the reasons for such a rejection. And there are judgments which says that these reasons has to be elaborative. It should not, because without a reason rejecting a claim, the liquidator would be called and liquidator would be directed and with liquidator would also be held responsible for not giving reasons for rejecting a claim. The liquidator shall communicate his decision of admission or rejection of the claims to the creditor and the corporate debtor within 7 days of such admission or rejection of the claim. Whereas in the case of CIRP, the liquidator has got no such obligation to communicate his decision of admission or rejection. In the case of CIRP, he is under obligation to upload a list of creditors, whereas in the case of liquidation, he is required to communicate with each. The determination of valuation of claims, where the liquidator shall determine the value of such claims admitted under section 40 in such manner as will be specified. And the regulation further says regarding submission of claims, a person who claims to be a stakeholder shall submit its claim or update its claim submitted during CIRP, including interest, if any, on or before the last date mentioned in the public announcement. So the only thing that we have to notice here is that he can also update its claim, and he can also say that my claim is same as submitted in CIRP. A person shall prove its claim for debt or dues up to him, including interest, if any, as on the liquidation commencement date. And the claims by operational creditor, it's regulation 7, it's 17, not really important to read. Regulation 18 and 17 is not really relevant to read all. And the forms for filing claims is form C, D, like operational creditors form C, and the financial creditor form D, workman form E, authorized representative of workman and employee form F, other stakeholders form G. And all these sections are now, let us see the verification, of course, is a bigger responsibility of the liquidator as compared to the RP. In this case, the verification has to be done intensively. All the understandings of it has to be completely accepted or rejected. So in the case of liquidator, the liquidator also becomes a kind of judicial officer, and the order of the liquidator rejecting a claim, it will be appealable. So the verification is in any case much intense and larger responsibility of the liquidator as compared to the responsibility of the RP. So this is appealable in various cases. So Ankit, you can take some of the judgments which are on liquidation, and this is actually very important, like in case we see the Swiss ribbon type.
So I believe it's already 2 o'clock when there are many judgments. So should we take this in the next part?
I think we can take this all the judgments on liquidation processes that we can take in the next part. And in case we try to see, let us try to see that the total still we have something like 40 kind of slides, and these are not 40, but in any case 30. So we can have part 3 for the verification of, and in fact, the entire claim verification during liquidation, that we can have at it as part 3 for, because we don't want to leave the hard work done by us, and it has to be adjudicated to all. So I think this is what for today. We will come for part 3 for claim verification on during liquidation, all the law, all the regulations related to claim verification during liquidation process, and judicial pronouncements during liquidation process. Yes, Ankit. I think we can close, or is there any question that we can take up?
No, I think that's it. Let's take this up next part. There are 3 questions. Let's try and deal with them quickly. One question is, there were no claims and there were no COC which was formed. On 85th day of the CIRP commencement date, there came in a claim from the OC. Now the question is that should COC be constituted at that time? I think yes. Why not?
You see, belated claim up to 90 days, that I think he has a
Is
right.
anyways, yeah, it anyways
He has a
allowed.
right. Yeah, up to 90 days he can file his claim, and then he can constitute a committee. I think it is valid filing of the claim, and the RP would be under obligation to constitute COC now at this stage.
You know, Rajkumarji is asking how to treat a claimant who has filed its claim during liquidation for the first time, whether he is bound to contribute to liquidation cost and also pending CIRP cost.
No, I
There's
think nothing like this, because as far as the contribution is concerned, the final contribution has to come from the assets of the company. Regulation 2A very clearly says that only financial institutions will contribute for the liquidation cost only. And there is nothing like that they will also contribute the CIRP cost. But however, in case there are funds available in the company, if there are assets sold, then first of all, the CIRP cost and liquidation cost will be paid.
Yeah, and also the interim funding, if any income which has come in during the CIRP process from the creditors, will be paid first. Yeah.
Yes, yes.
So thank you, everyone, and we will see you next week.
So
Thank
I think the next week we will have part 3 of claim verification during liquidation process, along with jurisprudence on this. Again, we will say that this is our way of learning or collective learning, and we will continue our effort of learning process. Thank you very much for being with us.
Thank you, everyone.